The First Amendment. So when you say the First Amendment, oftentimes we think of freedom of the press. We kind of have those two things are synonymous in our heads. But the First Amendment's actually a lot more than that. There's actually five things that are conferred in the First Amendment. So the First Amendment's kind of inextricably linked to journalism in a lot of people's minds. And most media law is going to be rooted in the First Amendment. There are also some state laws that come into play, as well as other federal laws that kind of interact with the First Amendment. So things like Freedom of Information Act, things like that kind of are kind of intertwined with the First Amendment. Now, the Supreme Court, since the 20th century, has started to open up and to really kind of enforce and strengthen the First Amendment. Prior to the 20th century, and it did start at the beginning of the 20th century, prior to that, all cases had been decided such that the government kind of won the case and the press didn't. But starting in the early 20th century and continuing on to today, more and more cases at the Supreme Court, which is where we really get the First Amendment enforced. Any kind of constitutional amendment gets enforced at the Supreme Court. So their rulings and how the Supreme Court decides cases really decides on how we as media practitioners are allowed to work. And so the fact that since the beginning of the 20th century and going forward, they've continued to strengthen the First Amendment is very good for the press and good for people in media and really good for the public as well. We've had a couple of little back steps along the way, but overall the trajectory is to enforce the First Amendment. So the First Amendment, as I said, confers 5 different rights to you, actually, not just the freedom of the press. But what we're interested in is this part in bold, that Congress shall make no law abridging the freedom of speech or of the press. As you can see, and as you go over in media law, there's actually a lot more to it than that. But that's what we want to specifically hone in on and focus on. So how has the Supreme Court gone about kind of strengthening the First Amendment? And what has it looked back on? Because the Supreme Court very much does not want to just make new rules and make these things in a vacuum. They want to rely on things that have already been said by people and draw on arguments that have already been made. There's basically 3 theories about why this freedom of the press is so important and why it's so important to our particular American democracy. The first one is by someone named Meiklejohn, and basically it boils down to everything worth saying shall be said. Then Blasey basically believes that there is a checking value of the press on the government. And then finally, the kind of most pervasive to this day theory is the marketplace of ideas theory, which is something that you might have heard about in other kind of venues. So I'm going to go through each of those. So Meiklejohn said, everything worth saying shall be said. Basically, his theory is that in order for democracy to work, you need to have informed citizens because we vote on topics. We vote for people who have, voting records in areas, and you need to understand what's being voted on in order to make an informed decision. That an informed decision is necessary to a healthy democracy, and so therefore, in order for people to be informed, we need a press. So the purpose for him of the First Amendment is to protect speech in the press so that citizens can make sound decisions in democracy. So especially when you consider that, our democracy is an experiment, as lots of people, if you study history will say, people were are still very invested in making sure that it functions as well as possible. And part of that is that if you are a voter, you need to make informed decisions in order to, continue our democracy in a healthy manner. So that's basically the foundation for Meiklejohn, that we need to be informed as voters in order to make informed decisions. Now, Blasey believes that the press is needed to keep the government in check, that the press is almost like we have the checks and balances in government. The press is almost another arm, it's another part. We've got the 3 areas of government, and the press is almost a 4th. That we need the press to basically speak truth to power, and that if they don't do it, no one else will. So that's another kind of angle on why it's necessary for the functioning of democracy. And the third theory, the one that kind of developed while free markets were developing, and this theory kind of is very much tied into kind of our concept of free trade and our kind of conceptualization of capitalism currently, is the marketplace of ideas theory. And with that marketplace of ideas, it's like the free market, that you can put forth a bunch of different ideas, you can put forth a bunch of different products, and the best one will win. And in the marketplace of ideas theory, the best idea is the truth. And so the concept is that when you put forth lots of different arguments, you have a big debate, that the truth is going to win in that debate. And part of the issue is that government kind of has a louder voice inherently, and that government could squash the truth and squash the best ideas just by the fact that they're more forceful. So that the First Amendment's necessary in order to kind of guarantee equal footing for all of the ideas, so that that way the government can't squash the truth if it doesn't please them. So those are basically, whenever you have a ruling at the Supreme Court that is for freedom of speech, it usually boils down to one of those three ideas, either Meiklejohn, Blasey, or the marketplace of ideas. And again, Meiklejohn is about informed citizenship, Blasey is about checking power, and the marketplace of ideas is that the truth kind of will rise to the top. And just to kind of touch upon two large cases involving freedom of speech, it involves this concept called prior restraint. Now, prior restraint means that the government basically can't censor you. Prior restraint is stopping something from being published. It's restraining you prior to print. So basically it says that the government can't stop the media from publishing something just because it doesn't like what it has to say. So Neer versus Minnesota in 1931 was kind of the biggest case in the early 20th century that really strengthened the First Amendment, and was one of the big cases that the rest of these cases are based on. So if any of you guys saw The Post a few years ago with Meryl Streep in it, that movie's about the Pentagon Papers. And the Pentagon Papers were a series of leaked documents that the Washington Post published, and that shed light on what was going on with the government and with regards to the Vietnam War. So when the government tried to stop them from publishing it, and in fact, if you've seen the movie, you'll see they threatened to jail them, they dragged them in front of Congress. But basically, what they said is they cited Neer versus Minnesota, and they said that, it's presumed to be unconstitutional. The idea of prior restraint is presumed unconstitutional. And the government argued that it was in the best interest of the public in order to keep this stuff from coming out, and that it was, a matter of government security. And basically, the Supreme Court set the bar very high and said that in order for something to be censored, then the government had to prove that there would be irreparable harm done by the publication of the papers in this case, or of whatever it was that they were wanting to publish. And so, yes, there is still the ability of the government to say that this would, harm national security. But you have the right to publish it, and the government has to prove that it would harm public security. So the burden of proof is on the government, and that's a really huge piece. So that is kind of where we're at. This ties into things like the Freedom of Information Act, which is something you may have heard about. And basically, the Freedom of Information Act is to get things that the government might want to keep confidential, and that they're citing issues of national security, and that freedom of information is basically saying, well, we have the right to see that information. And then you basically have to kind of, prove that it's going to be of harm to the country to not give us that information. So that's kind of the rulings that most of the rest of the stuff is going to be based on. So next section, we're going to start talking about the largest thing that people do get brought to court on, because it's usually not freedom of press. It's once you have actually published something, is it defamatory or is it libelous?